We're talking now about legal news. There's lots of very interesting legal stuff going on around the world at the moment. And to talk us through it is Andrew Eborn, who's a barrister and broadcaster. Andrew, good evening.
Good evening. It's such a delight to see you again. How are you doing?
I am very well indeed. How are you?
I am incredibly well. It's lovely to
Good.
see you.
Thank you.
But you're right. We call it sort of Andrew Eborn's greatest writs as opposed to the greatest hits.
Very
Um,
good.
I thank you. And there's been loads of these around the world at the moment. We had lots of fun and games last year with everything from Wagatha, Christie to Johnny Depp and Amber Heard and all of those sort of things. But a big case which has happened today, as you know, 15 rounds of voting ended up in the States with Kevin McCarthy being elected finally the Speaker.
After
Hurrah,
a punch
hurrah.
up.
Yeah, there was all sorts of shenanigans. Well, it's not the longest one I can tell you though in history, Petrie, because I think the record is 133 rounds. Can you believe it?
Gosh.
Which happened in 1855. With I think it was Nathaniel Banks eventually got elected there. But what happened to celebrate the Speaker's election? One of the Congresswomen, Republican Congresswomen, Marjorie Taylor Greene, basically posted a video on Twitter and YouTube and various other places to her 1.8 million followers, celebrating and talking about her part in it. But she used a soundtrack from Dr.E, and the doctor was not very impressed. So he threatened to sue her. And it raises all sorts of things because you will know that lots of political candidates have used music
Yes, they
as a
walk
sort
it
of
when they're about to be elected or when they are elected. They walk into some music, and it has caused some problems before here, where artists have said, "I don't align myself with your politics. Stop using my music." But how do they?
yet to find an artist who's been happy
Yeah.
with that sort of stuff. You might remember Donald Trump, and the first time I heard Donald Trump, once he won, I think everyone was surprised apart from us because we sort of predicted it. But he had the Rolling Stones classic from 1968, You Can't Always Get What You Want, which I thought was like a glorious thing. And the Stones really objected to that because they didn't want to be associated with Trump. And Trump's been famously using all sorts of people from Adele to various others in his
But how
campaign.
can those artists stop them from using it? Because presumably, if they pay the rights, the cost, then they have a right to use it.
Yeah, and the law's changing, and this is what's happening because so many people have objected to it. So the basic rights is under copyright. In this country, we have it under the Copyright Designs and Patent Acts, hurrah, for the benefit of those listening in black and white. That's what I'm holding up at the moment. But the Copyright Designs and Patents Act, it gives the rights for a copyright owner. They have a number of things to stop you copying your work, to stop you playing it in public, and stop you reproducing it. So as a general principle, the owner of the song could stop people using it. The problem is a lot of venues have what are called blanket licenses. So rather than having to negotiate with all the individual copyright owners, a license is given to them to cover, allowing them to play all sorts of music,
Which they pay for, so it's
which they
all,
pay
yeah,
a blanket license
yeah.
for. That has changed fairly recently where they're starting, especially in America and over here, starting to exclude effectively political campaigns because so many artists have complained about it. So there are possibilities now that people can opt out, if you like, of having their particular songs played at political rallies. But you still get that sort of grey area where certain venues have got these blanket licenses entitling them to do anything.
It's very interesting. I want to move on to another showbiz issue here because I find this a very interesting case, and I can't see how Paramount are going to win it. This is the Paramount is being sued for $600 million over child nude scenes in Zeffirelli's 1968 Oscar winner Romeo and Juliet. And this was after the statute of limitations was lifted, wasn't it, in California
Yes.
for child abuse.
Yeah,
So,
and so effectively what happened, you're absolutely right. It's a huge writ which has been put. The media slightly misrepresented what actually happened. But there was the statute of limitations. There are normal limitations for everything. And you have to distinguish between what's a civil case, where there are statute of limitation, and what's a criminal case. And classic examples of that, things like sort of O.J. Simpson and so on and so forth, where he managed to get off from the criminal case, but was still subject to the civil case, and he had to pay damages in that particular side. So what happened is the statute of limitation, there was an extension until the 31st of December last year where claims could be brought. And after that time, it then goes back to the general rule that you have to, basically the statute runs out when you're 40. But two people are involved, Olivia Hussey, who was 15 at the time of Romeo and Juliet, and Leonard Whiting, who was 16 at the time. And they appeared in Zeffirelli's fantastic 1968 version of Romeo and Juliet. But within that, there were scenes when they were nude. And they were first of all told when they signed the contract that they would be wearing bodysuits and there would be no nudity. On the day of the shoot, and it came fairly near the end of shooting, Zeffirelli said to them, well, hang about, it's not going to look right, the scene. We'll put body paint on you and we'll shoot it in such a way that you won't see the nudity. In the end, what happened is that you could see bare buttocks and you could see breasts and so on and so forth. And so after several years, I mean, it's over 70 years now, they're basically, because they're now 71 and 72 respectively. What's happened is they're turning around and they're suing Paramount for two things. One is for the 500 million, which they're claiming what is basically engorged profits, so any ill-gotten gains, and they reckon from the licensing of Romeo and Juliet and all the other income, about 500 million's been raised. And the other thing is the 100 million, which is punitive damages, which they're looking for.
I mean, it is hard to see how Paramount is going to get away without paying something. This will probably be settled out of court, I would guess, and there will be an undisclosed sum of money given to these two performers, because what they're saying is irrefutable, really.
Well, it is a fact, and you cannot consent to abuse or a crime. And looking at these sort of movies, I mean, in a similar sort of time in 1978, you had Brooke Shields appearing in a movie called Pretty Baby, where she portrayed a child prostitute. And there was nudity in that again. She was only 12 at the time. And just a couple of years after that, in 1980, she was in Blue Lagoon.
Yeah.
And again, there was a lot of nudity then. She was only 14 at the time, 14, 15. And you start looking at those sort of cases. And again, there was Paramount involved with Pretty Baby as well. And you're right, is you cannot consent to those sort of things. But most of these things get settled out of court in the same way as Prince Andrew, with his case. It was a civil case again, and that was settled out of court. You had similar sort of things with, I mentioned about O.J. Simpson, but you also had the Bill Cosby case. Same sort of thing, where he paid $500,000 to somebody who was underage and who he assaulted in the Playboy Mansion. And that was again under the same sort of legislation where they extended the statute of limitation under what's called AB 218 to deal with that sort of side.
It's a fascinating case. I wonder if we'll ever know what happens with it. I want to move on to Usain Bolt, because he has managed to trademark his signature pose.
Yes.
And then Mariah Carey, though, who wanted to be known as Queen of Christmas, wasn't able to trademark that. I mean, first of all, how do you trademark a pose?
Well, it's interesting because it's slightly misrepresenting it, because what it is, it's actually the iconic look. So the classic Usain Bolt pointing, if you like, into the air like that.
Yeah. I'm sure somebody's done that before him.
Oh, I'm sure they have, and there are various victory poses that you have. But rather like and this is what inspired it, is they had Mo Farah. He did the Mobot, the thing where he did his M on top of his thing. And that was actually suggested to him by Claire Balding. She was saying, you've got to have a victory signal.
Yes, it was on Question of Sport. They were taking the mick out of him, weren't they?
Absolutely. Yeah. And Claire Balding suggested it to him.
Yeah.
Well, Mo Farah managed to trademark that look. In terms of, you can then put that particular logo onto merchandise and make an absolute fortune. You remember, for example, Michael Jordan with what they call the leaping into the air and doing this slam dunk. And that's been put on Nike clothes and made zillions of dollars every single year as a result of it. A Jumpman, it's called. Well, basically what happened, Usain said, look, I'm going to use this signature pose. I want to do it on clothes and in health clubs and various other bits and pieces. And he was successful in trademarking that.
That's extraordinary. I find that, if it was me wanting to trademark that, I wonder if I'd get the permission to do it. But Mariah Carey famously failed to secure what she wanted to trademark, which is the Queen of Christmas.
Yes, and you're the Queen of the Night, as we've said beforehand. But
let's trademark it.
No, but we love it. I will help you because, as I think I mentioned last time we discussed things about trademarks, is that I own the trademark for the word octopus, because that's the name of my company, Octopus TV, and also the word failure, because I wrote the book of failure. So I own that in various classes. But Mariah was not successful in claiming to be Queen of Christmas, basically because there were a couple of objections. There was somebody called Darlene Love, who was called the Queen of Christmas a long, long time ago, and she appeared on all sorts of shows. But also somebody called Elizabeth Chan, who is an artist again in the States. And every year for the last several years, she's released an album just of Christmas songs. And she says that she's got a better claim to be Queen of Christmas than Mariah. So when Mariah applied for the trademark, basically Elizabeth Chan put in an objection and said, well, hang about, you can't have it because I was this and nobody can really claim to be Queen of Christmas and therefore you can't do it. Now, Mariah basically lost by default because she didn't respond to that objection. And personally, having been successful in securing trademark protection for a number of people, including myself, for different things, I think she could have fought a little bit harder on that one.
Yeah. I mean, it's, but the ego. I mean, it's just the ego of wanting to call yourself that. Just very quickly at the end here, famous legal actions turned into films, musicals and West End plays. I can't think of anything worse than going to see Vardy v Rooney. I thought we saw enough of it on the television. But it's big business now to do these sort of court cases on
huge. And on the serious side, we've had in the theatres, She Said, talking about Harvey Weinstein. You've had on the television at the end of last year, you had Prince Andrew, the musical. I'm sure that was top of your Christmas list.
Top of my list. Yeah.
I tell you what I loved about that. They to their credit, Channel 4 hired one of these billboard things and they put it on a vehicle and they drove down to Pizza Express in Woking, and basically said you better have a good alibi if you miss it, is what they said.
That's very clever, Mark.
They were very clever. Yeah. I like that. But what's going to happen? You're right. It's now been turned into Johnny Depp and Amber Heard are all sorts of the fodder for the media, so they're turning around and making those into TV series. But you've also got this West End play. It was so successful last year. They're going to be opening again in a few months. I think it's April. I think they're doing it, and they invited me along to the press preview, which would be fantastic. You're very welcome to accompany me. And what they've done is they've taken the transcript from the Wagatha Christie case, and basically a scouse trap, if you remember that wonderful case where there was that thing about Colleen Rooney was having all of her different posts being leaked to the press, and she needed to find out who it was. And so by a process of elimination, she whittled it down until she could work out just one person could have received this particular post and leaked it to the press. And she revealed it was ...
I mean, it's just, I just wonder, I mean, we see all of these things play out, don't we, anyway on the television, why you would want to go and see it again. But in Netflix, the Staircase, I don't know if you know the famous case, the Staircase, and they've now got a drama version of that and a documentary version of that. And that seems to be the way they're going now, is they will dramatise something and have a documentary, and you can watch both of them. And I guess that's quite an interesting way to do it. Depends how you want to absorb your information.
Love it. It's like medical things, that people love crime, they love the legal side, and fact is much stranger than fiction in so many cases.
It really is. Andrew, brilliant. Thank you very much indeed. Andrew Eborn there, barrister and broadcaster.